I looked at the program. The presenters and the participants in this program present really a stunning array of scientific and practical experience in the area of water management. It's daunting for a layperson in this arena of advanced science to say something that is relevant and that is helpful to you. Nonetheless, there is an importance in understanding that no matter how elite the science, its reliability and its relevance must ultimately be judged by persons such as I, who start at ground zero and must be taught and in turn must rule and hope that we get it right. Each side of the equation, the legal side of it and the science side of it, has a common goal: to get it right and to apply it properly. This is an exciting time and an exciting subject. I envy those of you who are actively involved. You're writing on a large screen with very large consequences. The intersection between law and science is ages old. Each has a profound effect upon the other, and often to understand the development of one, a person must understand the development of the other. Commonly, science precedes the development of law. There would be no need for speed limits, driver's licenses, or volumes of state and federal regulations if science hadn't developed an automobile and other horseless contraptions. The development of embryonic implants, cloning, has sent the legal system scrambling to determine uses and consequences, often calling into question moral views. Stem cell research has labored around legal confusion and indecision. Sometimes law has inhibited the development of science. If proving the earth was round might cause you imprisonment, or worse, you might find another area of research. This week, there was a classic example, I suppose, of that. Some Italian scientists were found guilty of manslaughter and face imprisonment for minimizing the potential effects of earthquake activity. Ultimately, there were deaths that followed the failure to predict accurately what was likely to occur, and the scientists face imprisonment. There are sometimes legal risks. Hopefully none of you is involved in any studies that might send you to the pen. Just don't make any mistakes ever. At times, law gets ahead of technology and sets goals that the science of the area is not capable of achieving fully. Years ago, the Idaho legislature required conjunctive management of surface and groundwater. The science of the time was not developed fully to address the issue with satisfactory certainty. The goal was essential, and it set a legal requirement that also required scientists to scramble to provide the information to meet that goal properly. It's remarkable how much has been done. Great problems very often draw solutions from committed people who have vision. That is one of the underpinnings of this conference. The management of water resources creates both opportunities for scientific development and frustrations that may accompany that development. There are vested legal rights that may at times frustrate results that seem logical in light of present state of knowledge and needs of society. Most of our water law that I'm familiar with developed in the context of surface water determinations. Vast and costly productive systems were created to distribute the water based on what could be seen and could be understood from that observation. Until the 1950s, in this area, in the Snake River basin, with which I'm familiar, pumping from the aquifer was incidental. The development of inexpensive electricity led to the rush to pump from beneath the surface in what was described as an unlimited supply of water. The effect of this in the long term were not generally foreseen. The concept of first in time, first in right, committed licensing of significant amounts of available water prior to the time that the pumping became so widespread. Were there enough water to meet all needs, the science of this program would have limited use. On the other hand, if we were writing on a clean slate without the history of vested rights, there would be simply the issue of how we allocate water for the greatest public interest and make decisions upon priorities along the line. Well, neither format exists. We have less water than is necessary to serve all needs. We have extensively developed vested rights that have legal, constitutional protection that cannot be disturbed except by agreement, forfeiture, or other legal mechanisms such as sale. Within this context, this science has a significant role that may have a major impact upon decisions that are made within the context of the existing legal system. That has already happened in the Snake River Basin adjudication, and I participated in that. My experience in the management of water resources progressed in reverse order. Of the 38 years I spent as a judge or justice, 26 were as a trial judge, beginning in a court that no longer exists. That experience had little to do with water rights or management of those rights. It did, however, have much to do with the evolution and application of a wide variety of scientific principles, theories, or oftentimes hocus pocus. As you've heard, it has become the duty of trial judges to sort out what science is reliable enough and in turn relevant to be considered in the resolution of cases. In the name of science, for example, we've heard people with advanced degrees say such things as cocaine is nothing more than a cup of coffee, that physics of a truck tire rotation is more complex than space flight landing a man on the moon, and that assembling shelves that would not collapse in a big box store was an esoteric science that could not be understood by a jury without the aid of a PhD physicist. The cost of scientific evidence submitted in a leaky condominium roof case in McCall, Idaho, exceeded the entire cost of the project in its initial construction. So within the legal system, this experience that had nothing to do with water management had a great deal to do with sorting out what science is appropriate to consider in deciding major issues, and explains some of the wariness that new science may encounter within the legal process. You've heard the term junk science, which developed in the legal system. It became the responsibility of judges to identify and exclude the junk from the science. It is against this background that I ruled that the science you are considering is not junk. It is science with sufficient reliability to be considered, and it had a significant effect upon the outcome of a basin-wide litigation. The Idaho Supreme Court agrees. What you are engaged here is in the science that may have a dramatic step forward in resolving issues of water management. It is fenced in to some extent by the fact that it cannot redetermine legal rights that are in place. It cannot speak to the question of whether farming or community or business development is most important. But it can assist us in determining whether within those contexts a need is actual or only perceived. My imagination is not good enough to envision all of the applications, but it is literally space-age technology that has profound potential, which I'm sure will be explored extensively by the talent that is here. I stood listening to some of the earlier discussions, and I realized how important it is that those of you that have the knowledge learn how to communicate it within the legal structure adequately so it can be understood by those of us who have not had those science backgrounds. It truly is critical. It's the art of communication in its most important way. I spent nearly 13 years on the Idaho Supreme Court and had the duty, in retrospect, the honor of authoring a number of major cases and disputes arising from the Snake River Basin. It brought home how diverse and difficult the issues concerning the use of a finite resource are. As was noted in the introduction, I retired from the Supreme Court as Chief Justice in 2007 and had every intention of doing nothing of significance for at least a year when I would decide what I wanted to do when I grew up. However, I was approached, as you know, about acting as a hearing officer for the adjudication. I couldn't turn it down. My ego was too large. The issues were too important to walk away. For those of you that aren't familiar, the eastern Snake Plain is a vast expanse of land that extends approximately 170 miles from the east of Idaho westward. Its significance to Idaho cannot be overstated. It's an agricultural breadbasket. It is a home to cattle, dairies, trout farms. It provides hydropower. Its economy supports municipalities. It is a homeland to people and a habitat for other living creatures. The eastern Snake Plain is a semi-arid belt that depends upon water for economic survival. Unregulated and uncontrolled water that falls from the sky would not support the development that has taken place. The water that can be and must be controlled flows in the Snake River and its tributaries and moves beneath the surface in the eastern Snake Plain aquifer. The river and the aquifer interact. The use of water from one has an influence on the other. As I noted earlier, in the 1950s, this fact became much more significant with the development of inexpensive hydropower and deep well drilling to tap that water. The development of more efficient watering systems reconfigured the relationship between surface water use and the water that recharged the aquifer. The development of new technologies opened up immense amounts of fertile but water-poor land agricultural use. This was a plus until it became evident that there were more demands on the water and more water was licensed than there was water available at times and locations needed. Hydropower, farming, including plants, fish, cows, municipalities, flood control, recreation, species preservation, each has its claim. We learned that even the mighty snail has a need for water that must be protected against even human needs. Anyway, my ego and the enormity of the enterprise, as I say, would not let me bypass the opportunity to plunge into this quagmire. The next 3 years consumed my professional life. I undertook no other legal projects other than 1 or 2 incidental events, because I considered this the one priority that I would have in my life following leaving the Supreme Court. Those 3 years were what I consider the most challenging and also the most rewarding period of my legal career. It is that important, no matter what role you play in it. Taking water management and dispute resolution out of the abstract and sitting face to face with people whose welfare and dreams depend upon whether there is or is not curtailment raises the stakes of responsibility. There is no one you want to see lose. Absent a lot of water falling from the sky, you grasp for science that will allow all the water users to continue what they were encouraged to do by our laws and policies in the first place. There was extended and complex information concerning the relationship between surface and groundwater. There was a body of science, a model that formed the basis for calculating interrelationships. But there were also questions as to the amount of water actually needed to meet crop needs. These questions had to be addressed within the context of the legal system of senior water users having licensed water rights, establishing amounts to which they were entitled. Could they require delivery of the entirety of their license rights when there wasn't enough water to meet all of the licensed amounts? The request for curtailment of junior rights followed, impacting many thousands of acres of productive land and many thousands of people. Evidence was necessary to determine if there was an actual shortage, that is, was there a need for the entire licensed amount justifying curtailment of junior users, or whether the needs were met without the extension curtailment that was sought. Personal experience of different growers had value, but we wanted more. The science involved in this conference was relevant to that issue and was used to address the issue. It wasn't a matter of redetermining the amount licensed. It was a matter of determining whether under the circumstances existent there was actually a shortage requiring the law to drop its heavy hand on the junior user. One of the most impressive things in the 3 years of hearings in which I was involved is that I never saw any party sponsor junk science. We had high-end experts, and they acted like high-end experts, not hired guns selling a product without a warranty. And this brings me to my final thoughts. The public trust in the integrity of the science used in the management of our nation's water is crucial. The sources of sunlight and water are irreplaceable. Unlike other natural resources such as oil or coal or the like, there is no substitute for water. Take away water, and there is not only no commerce, there is no life. The proper management of this indispensable resource should be a calling, not a job. It is too important for gamesmanship or junk science. When I grew up, there was a strong belief that good science could solve almost any problem. That belief seemed to fade in the face of world problems that appeared to never end. It has taken a body shot when you see doubtful science sold in the marketplace of lawsuits and used in the political arena for ends that may have little to do with the public good or understanding. The reality is, however, that good science, applied to proper purposes, solves problems. It often is our last resort. It is often the only thing that stands in the way of hardship and unacceptable results. As the magnitude of difficulty in the management of our water supply grows, the need for constantly improving science to answer critical questions grows. This forum stands as a strong affirmation of the commitment to do the right things and to do them right. The rest of us depend upon you. Good luck.